Speaker. Honourable colleagues, I'm pleased to rise today to speak to Bill S-251, and I thank Senator Couture, sorry. Senator Couture, for introducing an act to repeal Section 43 of the Criminal Code. In addition to being call to action number 6 of the Truth and Reconciliation Commission, efforts to repeal Section 43 have been a multi-decade campaign. Section 43 of the Criminal Code permits the defense and justification for violence perpetrated against children by teachers and parents in the name of correction. When this provision was created 130 years ago in 1892, the use of physical punishment was authorized by men to discipline their property, from animals, employees, wives, prisoners, and children. The effects of physical violence as disciplinary punishment have been proven to be so deeply harmful that the practice has since been rendered both draconian and barbaric. The long-term effects of physical punishment are well documented, and the negative impacts were well articulated by Senator Couture. When one looks to the research on the effects of physical punishment, the message from the research is very clear. The risks and harms associated with physical punishment are rife and sometimes irreparable. A major 2002 meta-analysis of 88 research studies found associations between lawful physical punishment by parents and 10 negative outcomes. Another major meta-analysis in 2016, which reviewed 75 research studies published over 50 years, involved a total of over 160,000 children, confirmed the findings of the earlier meta-analysis and found evidence of associations with 5 more negative outcomes. Of these outcomes, they include the physical punishment is associated with increased aggression in children, and the research demonstrates that children who have experienced physical punishment are more likely to be more aggressive to their peers, to approve use of violence in peer relationships, to experience violence from their peers, to use violent methods to resolve conflict, and to be aggressive towards their parents. One of the reasons for this is that by being subjected to physical punishment, children learn from their parents that violence is an appropriate method of getting what you want. Presumably, we do not wish to perpetuate such lessons. The many negative effects of assaulting children are now undeniable. Indeed, even in the 2004 Supreme Court of Canada case in the Canadian Foundation for Children, Youth and the Law versus Canada, not one single expert witness in the case suggested that there was any benefit to physical punishment. The Supreme Court also reiterated in that case that physical punishment is not any benefit to children. Then why keep this provision, you might say? Why did the Supreme Court of Canada not rule it unconstitutional in total? It must be, but that there are cases in which it is in the best interest of the child. The Supreme Court's conclusion was not that physical punishment could be in the best interest of the child. Rather, the court clearly held that the best interests of the child, which would be served by preventing physical punishment, may be subordinated to other concerns in appropriate contexts. That is the context in which they set confusing and seemingly arbitrary criteria in which it may still apply. In attempting to provide protection for teachers and guardians who apply physical force to children in minor cases, the court allowed this defense to continue. To illustrate this point, I told this story in the previous iteration of this bill when it was advocated by our dear former colleague, the Honourable Murray Sinclair. At the time, I discussed the reaction of my eldest child to that court case in 2004. My now adult children were of the age targeted by the decision. My wonderfully astute son, Michael, was 13 years old, and my equally wonderful daughter, Madison, was 5. My son had watched the case with interest and had his own older brotherly interpretation of its outcome, particularly the rule restricting the availability of the defense to those inflicting physical punishment to children between the ages of 2 and 12. What was Michael's concluding pronouncement? "Nobody can hit me," he announced, "but we can all hit Madison." What my son zeroed in on then, and what we must also now recognize, is an absurd and atrocious reality at the core of Section 43. No child should have to wait until they are a teenager for the right to have legal protection from harm that we now enjoy as adults. Nor do we want them to risk learning that they deserve to be assaulted, and that worse still, it is for their own good. By the time they are older, children who are routinely assaulted as an intended means of correcting their behavior may suffer in ways that significantly and permanently negatively impact them and future generations. Why are we even leaving a remote possibility that this defense can be used or perpetuating the myth that this is okay in any case? The TRC's call for the repeal of Section 43 emphasizes the role that physical punishment and the belief that it should be inflicted on children with impunity in the abuses perpetuated in residential schools. The trauma experienced during childhood by survivors of Canada's residential school system has been ongoing and intergenerational, continuing to have not just negative, but sometimes devastating consequences for their families and communities. This is the 18th, colleagues, 18th iteration of this bill, and we still have a gap in our law that allows children to be assaulted. With each iteration of this bill, the evidence in favor of its passage mounts. We owe it to all children, past, present, and future, to remedy the continued condemnation of the assault of children. It is time to enact the calls to action and the calls for justice of the TRC and the Missing and Murdered Indigenous Women and Girls Inquiry, as well as the UN Committee on the Rights of the Child. It is long past time to repeal Section 43. It is also time to provide the supports with and for children. Alas, this is not the focus of this bill, but it certainly underscores the need for far more work to remedy many inadequacies and the nature of our lack of support for children and youth in this country. Miigwech, merci. Thank you.